Let's also tell you that in the judiciary, we understand that the Court of Appeal has set aside the Lokoja High Court order against the Economic and Financial Crimes Commission and its chairman, Oluwatodimu, in a contempt case filed by former Kogi State Governor Yahaya Bello. The Court of Appeal, presided over by Justice Joseph Oke Oyewole, granted the EFCC's motion for stay of execution and proceedings in the contempt case pending before the Kogi State High Court. The court held that the motion ex parte had merit and adjourned the hearing of the motion on the notice to May 20th, 2024. It also ordered substituted services of all processes in the case to be pasted at Yahaya Bello's last known address in Abuja. The affiliate court's decision has halted the contempt proceedings against the EFCC and its chairman, and allows the appeal filed by the anti-graft agency against the ruling of the Lokoja High Court to proceed. Of course, to give us insight on this, we are joined on the news by Legal Practitioner and Principal Partner at Oluwatodimu IGE and Associates. Joining me is Oluwatodimu IGE. Thank you for your time. Now, let's talk about the legal reasoning behind all of this. What do you consider the legal reasoning the Court of Appeal is likely to have, considered in justifying this particular move?
All right, thank you for having me. Now, the position of the law is very clear that it is within the right of parties to appeal a decision of a lower court. Now, having said that, what the EFCC has done is to approach the Court of Appeal to say, the lower court in Kogi has given a decision that we are not comfortable with, that we intend to contest. So they brought the application to the Court of Appeal as of right to say, we are not comfortable with this, we do not agree with this order of the lower court. So what the court has said is, the application was brought ex parte. So an interim, a stay of proceeding was granted pending the time of hearing the appeal on notice, which you have earlier stated that the hearing will now come up on the 20th of May. So as it stands, the Court of Appeal only honor the trial provision of the law that it is within the right of parties to appeal a decision of the lower court.
Now, considering the procedural details like the adjourned hearing and substituted service, what is the likelihood of a successful appeal by the Economic and Financial Crimes Commission against the Lokoja High Court's ruling?
Now, as it stands, now that the EFCC has filed an application to the court to say that we are contesting this judgment, the court has now said, go ahead to serve your application on the other party. Now, it is also the right of the other party to give a response, to give a defense to whatever has been filed, to say, no, we believe that there is merit in the decision of the lower court. So it is on the strength of the evidence that they also adduce. It is on the strength of their own application to the court that the court will now look into submissions, the submission of the EFCC and the submission of Yahaya Bello. The court of appeal will now look at it and give a decision based on the merit and the value of whatever they have put forward to the courts.
Now, this case involves, like you mentioned, the former governor of Kogi State, Yahaya Bello, and the anti-graft agency. Now, how might this specific situation and the Court of Appeal's decision impact public perception, particularly in the areas of accountability and the fight against corruption in Nigeria?
Now, the truth of it is that, it's quite unfortunate. Well, it is within also not as much as I say that it's unfortunate. It is also the right of parties. When the matter is brought to court, it is within the right of parties to contest whatever, because like we say, it is rightly enshrined in our constitution that parties are entitled to fair hearing. It is an essential part of our constitution that parties are entitled to fair hearing. Now, having said that, the courts should also bear in mind that justice must not just be done, but it must be seen to be done. And in a situation whereby the court is the last resort of the common man, the court is the last hope of everyone. If we go to court, we expect that we get justice. So the Court of Appeal must ensure that justice must be done, and not just be done, but be seen to have been done.
Now, beyond this case, what broader trends does this situation highlight regarding potential conflicts between state high courts and the federal anti-graft agencies in pursuing corruption investigations. And also just, joined to this, does this look like a long judicial journey between the governor and the agency?
Well, as it stands, it's evident that it might be a long journey because, as you know, corruption, they say that corruption fights back. And when it comes to our advocacy system, our litigation, the processes can be long-term, considering all the, you'll see that this is only a preliminary application. They have gone to the Court of Appeal. They would also, I'm sure that most likely one of the parties who intends to contest this might still get to the Supreme Court. After the court that makes a decision, this is just a stay of proceedings or contempt. We have not started trying the case on its merit. So, you know, it's going to be a long drawn battle, except any of the parties concedes.
All right. Thank you so much for your time on the news, Oluwatodimu IGE.